Hello and welcome to the Law Lab YouTube channel. Here we dissect and unpack everything legal. My name is Aaron Asiedu-Antwi. Today we are looking at law of contract, specifically mistake, and specifically we are looking at the common mistake. In our previous videos, we've treated mutual mistake, we've treated unilateral mistake as to the identity of the contracting party, and today we are looking at finally the common mistake. Now, common mistake is generally different from unilateral mistake and that of mutual mistake, in the sense that here it's either both parties, there is an agreement between both parties, but either of them or both of them are mistaken on a basic fact. However, they agree and there is an apparent agreement between the parties. One thing we should know is that common mistake, there are three types of common mistakes. One, we will look at mistake as to the existence of the subject matter of the contract. Mistake as to the existence of the subject matter of the contract. It is also termed as res extincta. Res extincta. And also we will look at mistake as to title. Mistake as to title, normally referred to as res sua. And the last one is mistake as to the quality of the subject matter. I'm taking them again. One, mistake as to the existence of the subject matter of the contract, which is also termed as res extincta. And two, we'll look at mistake as to title, which is also termed as res sua. And the last one is mistake as to the quality of the subject matter of the contract. Now let's pick them seriatim. That is, the first one we'll be looking at mistake as to the existence of the subject matter. Let me put this out. When it comes to common mistake, the court would assess first to ascertain for itself that does this common mistake goes to the fundamental root of the contract, or is it so fundamental to make the contract void? That is what the court will check. Now, when we talk of mistake as to the existence of the subject matter, let's say I contract A contract with B on a certain subject matter. Surprisingly, they end up and the subject matter itself is not in existence. That would technically make the contract void. And so we will look at the case of Kuturi versus Hasty. Kuturi versus Hasty, where there was an agreement between the parties that the seller should ship a corn from Salonika to England. Unknown to both parties, when it goes to Tunis, due to heat, the vessel handlers unloaded the corn and sold the corn in Tunis. Now, the vessel gets to England, there is no corn. The buyer says that since there is no corn, I'm not going to pay. The seller says you must pay because I got it boarded on the vessel, and if you have anything, you must claim your money from insurance brokers. The court said no. Since the subject matter is not in existence, they rejected the argument of the seller and upheld that there should be no contract. However, there is one thing you must know, that if one party guaranteed or impliedly promised the existence of the subject matter of the contract, then that contract cannot be void. So, though there is a contract between A and B, and A is giving all the assurances guaranteeing that this one exists, when we later find out that it does not exist, we wouldn't say the contract is void, but we will ensure that that common mistake would go against A. And so we can look at the case of McCrae versus Commonwealth Disposals Commission, where the defendant invited the invited tenders for the purchase of an oil tanker, which he described as lying on the Jomant Reef. And the plaintiff submitted his tender, and later the tender was accepted. But he found out that there is no oil, or they said there is no Jomant Reef. Now, the plaintiff sued for damages, and the defendant promised and stated that the existence of promise, in fact, the court held that the defendant promised and stated the existence of the tanker to the plaintiff, who merely relied on that, and that there is no common assumption of the existence of the subject matter and that the defendant must be liable. Since you guarantee that you cannot plead under common mistake, and in that particular instance, you, the defendant, must be liable. And we can also actually infer or look at Section 9 of our Sale of Goods Act at 137, which says that in a contract for a sale of specific goods, there is an implied condition on the part of the seller that the goods are in existence as at the time when the contract is made. So if you are entering into a contract with any person and it is for a specific good and you guarantee that it is in existence, then you must pay, you must actually be able to provide the said goods as of the time you contracted with it. The next type of mistake or common mistake we are going to look at is mistake as to this title. Mistake as to the title, which I term or I mentioned to you that it is also called res sua. Res sua. A simple understanding of it is that I own a calculator, and let's say Jacqueline owns a calculator. I find that calculator. I move ahead to sell that calculator to Jacqueline. Jacqueline didn't know that, oh, this is my calculator I've been complaining of that it got lost a number of days ago. Well, I also do not know that it belongs to Jacqueline and I sell it to her. The point over here is that when Jacqueline finds out that this is her calculator and that she owns or she has the title already, then that contract technically becomes void. Jacqueline can just set the contract I had with her by selling the contract, the calculator to her, because she cannot buy her own property. As simple as that. The next one is mistake as to the quality of the subject matter. Mistake as to the quality of the subject matter. Genuinely, I may go into a contract with Jacqueline looking for a certain brand of an item or a good. Now, it ends up that the item or a good we are talking about may not be the original, but it's a common mistake that we all presume that it is the original. When that's in that particular instance, Jacqueline or myself cannot void the contract. It becomes only voidable because it is only the quality that has actually skipped, or we both mistakenly believe in that quality. Now let's look at the case of Leaf versus International Galleries Limited. Leaf versus International Galleries Limited, where the plaintiff bought a picture called the Salisbury Cathedral from the defendant. And now both of them believed that the said picture was painted by one constable, but they later found out that it was not. The court held that the mistake was not sufficiently fundamental to make the contract void. And since the parties agreed in the same terms on the subject matter of the specific picture, so both of us, in a mistaken belief, thought that, well, this was painted by a constable, but it ended up that it wasn't constable. In that particular instance, the court is saying that that mistake, that common mistake shared between us, is not so fundamental to go to the root of the contract to void the contract. Thank you very much for sticking through with me on common mistake. And I am so much grateful. In our next video, we'll be looking at the position of law in equity as to how equity treats mistakes. We know common law goes with its rigidity of voiding or emptying the contract, which we all believe that somewhat is very harsh. So in our next video, we'll be considering equity, how equity deals with mistake. Today, we've looked at common mistake, and I quickly mentioned to you, or I mentioned early on, that there are three types of mistakes. Three types of common mistakes. One, mistake as to the existence of the subject matter. Two, mistake as to the title. Three, and mistake as to the quality of the subject matter. In the first one, that is the existence of the subject matter, where the subject matter does not exist, it voids the contract. However, where one person guarantees or one party guarantees the existence and later we find out that it does not guarantee it, you pay for damages. You wouldn't say it voids the contract. The second one is to the title. I mentioned that you cannot sell the same someone's property or a property that the person owns title to the same person. So I own a calculator, then I it gets lost, somebody gets it and sells it to me, it wouldn't work. You may consider the case of Cooper versus Phipps. Cooper versus Phipps. And also the last one is mistake as to the quality of the subject matter. That is a proper common mistake because we all believe that this is of a certain quality. Later we found out that that is not it. In that particular instance, the court is saying that it is not so fundamental to void the contract. It is not so fundamental to void the contract. Thank you very much for sticking through with us. This has been the Law Lab. Thank you very much and catch you in our next video.